Let me introduce our fine panel. First, I'll start on the far end there. Chad CATALINO. Chad is the supervising attorney of the misdemeanor division at the Muskegon County Public Defender's Office. He's from Muskegon. I graduated from Muskegon Catholic, then he went to GVSU, and then to Michigan State Law School. In 2013, he was awarded the Michigan Foster Care Review Board Child Welfare Parent Attorney of the Year Award. Well, that was a mouthful. Thank you for being with us, Chad. Next to Chad is Heather Garretson. Heather Garretson worked in the U.S. Attorney's Office prosecuting federal narcotics cases and arguing before the 8th Circuit Court of Appeals. She then practiced white-collar criminal defense before taking a position as law professor, where she continued her interest in criminal law through scholarship and the State Bar of Michigan criminal law committees. She now focuses full-time on smart justice reform and speaks nationally on collateral consequences. Please welcome Heather Garretson. Ooh, our sound guy's here. Next, we have Judge Raymond Kostrzewa. He is a graduate of Michigan State University and the University of Detroit Law School. He joined the Muskegon County Prosecutor's Office and was soon promoted to Chief Trial Attorney. In 2014, he was appointed to the 60th District Court bench, and in 2016, he was appointed by the Michigan Supreme Court to serve as Chief Judge of Michigan's 60th District Court. Judge Kostrzewa. And finally, we have Prosecutor D.J. Hilson. He is a graduate of Marquette University and Thomas Cooley Law School in Lansing. In 1999, he became the assistant prosecutor in Muskegon County. During his 13 years in that role, he handled cases in the district court, circuit court, and family court. He has tried approximately 70 felony cases, including several murders, violent assaults, and criminal sexual conduct cases. In 2012, he won the primary for prosecutor and was sworn in as Muskegon County Prosecutor January 3rd, 2013. And currently, he's a member of the statewide Criminal Justice Policy Commission. Please welcome Prosecutor Hilson. I have just a few things I'd want to start on Debtors Prison with a PowerPoint, just some statistics that we maybe can all work with. Hopefully I won't say things that the panel was already going to say, and then I'll let the panel speak on the issue and ask them some questions. Debtors' prisons are illegal, and they have been for quite some time, almost 200 years in the United States. And we also have the 14th Amendment, which is over 100 years old, which promises two things: due process and equal protection under the law. So this idea of a debtor's prison seems problematic and is unconstitutional, because it would mean that someone who is poor and unable to pay fines, fees, and bail and other things is receiving a harsher sentence for doing the same crime as someone who isn't poor. And yet, today, the question we're asking is, do we have a modern-day debtor's prison? Do we have a modern-day debtor's prison due to people not being able to post bail, not being able to pay their fines and fees, their legal fines and fees, from, say, tickets to fees, court fees and things like that, even probation fees, and they end up in jail as a result of not being able to pay their fines? Is that a modern-day debtor's prison? And that's the question we're going to be addressing. And let's just give you some mass incarceration data to keep in your head. The United States has 5% of the world's population. and 25% of the world's prison population. That includes jail. So we have prison and jail. There are 2.2 million people in prison or jail in the United States. About 1 in 110 people. There might be about 110 people in the room, if that gives you an idea. About 626,000 of those 2.2 million are in our jails. We got about a little over 3,000 county jails in the United States. And in the 1970s, though, and prior, we had less than 500,000 people incarcerated. And now we have 2.2 million. Now our population has gone up, but not that much since the 1970s. 70% of the people in jail, this is not prison, this is jail. So our Muskegon County Jail would be an example of jail. 70% have not been convicted of any crime. They're simply awaiting trial and have not been convicted yet. This is a national statistic. And 4.7 million Americans are on probation or parole. Added with people who are incarcerated, that means about 1 in 35 people who are under correctional supervision. So you can see in the 20s, the amount of people in jail and in prison, it's pretty low, and then in 1980, we see a huge spike in the number of people incarcerated in the United States. That's both in jail and in prison. Is this because crime went up? Doesn't appear so. If you see the lines below, the blue lines are the amount of property crime and violent crime. It's actually trending down, but the incarceration rate is going up. How do we compare to the rest of the world? We're a little off the map there. 716 per 100,000 people are incarcerated. And here we have other countries. The next most incarcerated is the United Kingdom, which is England, includes England. And that's about 147, where we're at 716. Few other things. Does this debtors prison create not just people in prison for not being able to pay fines, but does it create a cycle of poverty? The unemployment rate of the formerly incarcerated is as high as 60%. What's our unemployment rate now nationally? It's about 5%. It's around there, I think. Yeah, a little over. Illiteracy rate is 4 times for inmates compared to the rest of the population, 4 times as high. Many people are in prison due to, again, not to be able to pay their fines, bail, fees, tickets. Muskegon Jail has a video conferencing, which I haven't been able to find out how much they charge. Maybe we'll find out. But nationally, it's about $1 a minute, and that's how you need to talk to people when they're in jail. Outside phone calls, I did check on that. A 15-minute call is well over $15 if you want to call into prison. So again, once you're in prison, it becomes expensive just to be there. And throughout the country, we've been asking then people to pay for their time in jail. So while you're in jail, you're paying like you're at a hotel. You're paying a daily fee that you get when you're out. And they range throughout the country from about $20 to $150, was at least the highest I could find, per day for being in prison. Or, I'm sorry, being in jail. Being in jail. Racial disparity, we're probably familiar with, part of this series. We have, you can see the rates for white people who are white or not and non-Latino is 366 per 100,000. Black, it's 2,209, and Latino is about 759 per 100,000. So there's quite a racial disparity in terms of people on basis of race, in terms of people who are incarcerated. So those are just some initial statistics here. So now let me turn it over to the panel with that little background there. Hopefully I didn't go too long. Why don't I start with Heather? Since, okay. Heather, can you give us some background on your thoughts on why is there a concern about a modern-day debtors prison, and what causes people to be incarcerated for inability to pay fines or bail?
Sure. If you don't mind, I'm going to ask the panel to chime in just to quickly go over the process of what it actually means. So I practiced in federal court. Everybody up here is in state court and in county court, so they can speak to what it actually looks like in Muskegon. So if you get arrested, so you're accused of a crime, and you get picked up and you get taken in, you will be possibly detained. You have a procedure in court called an arraignment, and that is when the charges that are against you are stated. In federal court, you get a lawyer for your arraignment. That's when you enter your plea, and that's when you talk with your attorney to the judge about how you get out. That is not necessarily true in state court, and it's my understanding that doesn't happen in Muskegon. Is that right? Sorry. Speak to that.
Okay. Yes, if you pay for your lawyer, then you get one. If you don't pay for your lawyer, then no, we are not appointed. The public defender's office isn't appointed prior to an arraignment.
Okay, so the bail decision, and you might want to say the process, just so everybody knows like what's happening in the system. So the bail decision is made at that time. So if you don't have enough money for a lawyer, that bail decision is made without a lawyer, and the judge sets the bail. And we can use the terms bail and bond interchangeably, although they essentially mean they're different, but we'll just use them interchangeably. So the issue now that has come up in sort of these conversations about who is inside because they cannot pay a bail really focuses on who is inside who has not been determined to have committed a crime, right? Because this is before any decision has been made about guilt, okay? So this is a pre-trial detention. Keeping that in mind, Michigan statutes tell the court and the attorneys when you're supposed to stay in jail. And essentially, unless you are accused of treason or murder, and there is a lot of evidence that you committed those things, you are, under Michigan law, entitled to bail. That's what the law says. And the law says that the court is supposed to look at a couple things to see if you should be able to go home pending the outcome or pending your charges. The court is supposed to look at the risk of you fleeing. The court is supposed to look at the dangerousness of your offense, what you're accused of, and the court is supposed to look at your criminal history. And frankly, I mean, those are reasonable things, right? If we want to keep a community safe, those are reasonable things to look at to say, you should probably sit here and wait, or you can go home. What is happening, however, throughout the country, and it's not unique to Michigan, is that we are setting bail because we are setting bail. I mean, bail is really a holdover from medieval law, and we do it because that's what we do. I mean, just because we are not out-of-the-box thinkers, and we are not thinking about other ways to both make sure our communities are safe and to compel people's appearance. So what the studies are finding, and Michigan's actually really rough to figure it out because different counties keep different data, but what the data is showing is that people who are impoverished are the most likely to not make bail. So most people who are inside because they cannot pay on a nationwide average can't pay $2,500. That's for a felony charge. 30% of people who are inside on misdemeanors can't pay $500. And the problem with that is not only that we have pretrial detention and a majority of people who can't make bond, who maybe shouldn't even be in on bond, is that there are really negative outcomes from being inside pretrial. We know the data shows that the longer you're inside, the more likely you are to take a plea deal that results in a criminal sentence. We know that the longer you're inside, the more likely you are to commit a crime when you get out. And we know that even a 2-day disruption in life is a real significant interruption in people's ability to succeed. Like, you know, if you don't go to work for 2 days, you get fired. If you get fired, you don't have a paycheck. If you don't have a paycheck, you don't have an apartment. So there's a real cascading effect from something that we do not necessarily according to the statute all the time, but just because we've done it that way. And that ends up impacting people who are impoverished much more than people who can pay and wait for a disposition of their case outside the trial.
Prosecutor Hilson, is the prosecutor there at the trial, pre-trial hearing? The arraignment, I'm sorry, thank you.
Well, offices are going to differ across the nation, across the state. My office, we attend maybe 2% of all arraignments. Typically, I don't have the resources to put a prosecutor down there, bottom line. The arraignments that we usually attend are the more high-profile cases, your murderers, the CSCers that essentially commit CSC against kids. We might appear at arraignment, but it's very rare that we're in court, just because, one, it's a judge decision, and two, I just don't have the resources to do it.
Okay. All right, and Judge Kostrzewa, was this been explained well? You can use that mic, or maybe this one, I don't know. Either way.
Well, I think it has been explained well, but there are a couple things that need to be added to this. First of all, both Prosecutor Hilson and my counterpart, and I want to make sure I get Ms. Garretson, they are correct that in Michigan right now, the majority of arraignments that happen, one, they're in district court, because that's where felonies and misdemeanors all start in district court for arraignment. The majority of those cases right now are not attended by a lawyer, and frankly, even for retained counsel, it's very minimal. Usually the retention of counsel happens after arraignment, but occasionally there's retained counsel that show up for the arraignment.
Retained counsel is...
Retained counsel means that you are hiring a lawyer, that you're not relying on the determination of, one, are you an indigent defendant, and are you entitled then to a court-appointed lawyer, for which Mr. Catalino's office handles the bulk of all those cases in Muskegon County that are state charges. So to explain, retained lawyer means a hired lawyer. I'll tell you this, though. I'm going to start off by saying I've studied a number of criminal justice systems across the world, and the statistics may be right. I'm not in a position to be able to refute those. We don't have a perfect system. We have the best in the world. It's predicated on the right to counsel, a right to a jury trial, a right to a fair and impartial decision, a right to a fair and impartial arbiter. The judge has got to be fair. And if the judge can't be fair in our system, we have to recuse ourselves. I mean, those are some fundamental concepts that are built into our criminal justice system that no matter how bad the statistics are, we've got the best in the world. There's a presumption of innocence, and it's real. It exists in every trial. I've dealt with this for over 2 decades. We have a good system. All right, so
yeah,
I'm going to start off by saying that we have a good system, and it works. Now, is it clunky at times? Can it be improved? Do the wheels fall off sometimes? You bet. But it's a system run by humans. And I'll tell you, it's predicated on every human that invests himself into that criminal justice system being the best they can be on that day in that case. And that's when it works the best. Now, that's my soapbox, and I'm going to get off it now.
It's all right.
Now, I can tell you this, that from a judicial standpoint, the judiciary in Michigan is looking at that issue brought up right now. Is it important to have a lawyer at arraignment? There's been a pilot project that just finished in the 63rd District Court, which is Rockford in Kent County, and the 61st District in Grand Rapids. They agreed to run a pilot program where they would have a public defender there at every arraignment. And I'll tell you, from a systems standpoint, the concern with the judiciary was, is this going to bog things down? Are we going to be so slow that we can't be efficient? Because remember, under our Constitution, we've got a right to a speedy trial and a speedy disposition of your case. And if this is going to slow things down so much that we can't move through the docket in an efficient way, that doesn't do anybody any good either. Now, I'll tell you, to the surprise of many, this pilot project really worked out well. And I actually spoke to a couple of the judges that headed up the pilot project, Jeff O'Hare and Sarah Smolinski, 63rd District Court judges, and it works well. And we are working right now with our Chief Public Defender to come up with a plan where we can have that in Muskegon, where we can have a public defender available for every defendant at arraignment. So we are thinking progressively, how can we deal with this issue? Because it's a real issue.
Can you say, when you say it worked well, why did it work well?
Well, first of all, it did not bog down the system. It didn't slow them down at all. Their cases moved at approximately the same rate through the system. They still moved cases. It actually resolved cases at arraignment. Because if somebody somebody has the advice of counsel at arraignment that can take a few moments with them, maybe it's a case that gets resolved right then. And if that happens, well, then it becomes more efficient. And so I think that it was to the surprise of many that it didn't bog the system down. Now, it's a matter of resources. Because I know Mr. CATALINO is going to say that our office, meaning the Public Defender's Office, is taxed to the max in terms of the cases that they handle and how they manage their cases and the volume that they are handling. And I know the Michigan Indigent Defense Commission is setting standards for the public defender to say, hey, you can't handle too many cases because you're not going to be effective, you're going to burn out, and you're not going to give good legal advice. So, I mean, it's a balance that has to be struck. But I just wanted to address that point that it is being addressed. And in Muskegon County, we are working hard to make available to every defendant a lawyer at arraignment. Now, second point. I think it's a fair summary to say those are the considerations that need to be addressed and that are addressed at the bail or bond decision at the initial arraignment. One is prior criminal history, strength of the case, and I think the other factor you said is...
The current charge?
Yeah, the current charge, the seriousness of the offense. Yeah. Well, really, there's a Michigan court rule, and a court rule is a rule set down by the Supreme Court of the state of Michigan that's binding on judges as to the procedure to be followed in a case. It's their procedural rules, not substantive rules, they're not statutes, but they are procedural rules that the court must follow. So the arraigning judge, a district judge in Michigan, has got to follow these rules. And it imposes on the district judge the relevant considerations that have to be taken into account at the time of setting a bail. And it's worth expounding upon because it does comprise those 3 or 4 things, but there's more to it. And I'm just going to give you those because I think if you're here, you're interested in this. So if you're not, I apologize for boring you. 1, the defendant's prior criminal record, including juvenile offenses. 2, the defendant's record of appearance or non-appearance at court proceedings or flight to avoid prosecution. 3, history of substance abuse. That was not mentioned. That's significant. The defendant's mental condition. That was not mentioned. That is very significant. Seriousness of the offense charge. The presence or absence of threats and the probability of conviction and likely sentence. So the strength of the case has got to be considered. It's a relevant factor that our Supreme Court says, judge, at the district level, consider this. The defendant's employment status and history and financial history, and so far these factors relate to the ability to post money bail. We've got to consider what, from the judicial branch of government, we call ability to pay, even at arraignment. And I'll tell you this, that I'm a relatively new judge. I was appointed in 2014. At every training conference that I've been, we've addressed several things. One is the ability to pay. It's been on the forefront of our consciousness really since Ferguson in Missouri. It's really been an analysis that we've been instructed to take from our Supreme Court. And the second point I want to make on that is I start with the presumption that somebody is entitled to a personal recognizance bond. In vernacular, we call that a PR bond or an OR bond, own recognizance bond. That means basically a signature promising that you're going to follow the court's orders, meaning you won't be involved in any more criminal activity while you're on bond, and that you're going to show up for all the appearances in court that we say you need to be. There's a presumption that you get a personal recognizance bond until you start considering these factors. Ability to pay is one of those. just one, but it is one. Availability of responsible members of the community who would vouch for monitoring the defendant. I mean, a family member saying, listen, I'm going to take care of this person. Listen, from a real life standpoint, when I look at a 26-year-old defendant in front of me with a history of maybe 5 or 6 felonies, and I have a family member that's coming in and saying, listen, I'm going to promise you that I'm going to take care of this person. How much weight do you think that has to me? Have they been able to prohibit this person from committing the 6 prior felonies that are on their record? To me, that has marginal weight, and I've got to value each of these considerations. How much does each one of these weigh? Sometimes one may weigh 10 times more than the other, but you've got to assign value to each one. But I'm just telling you, I take a real common sense approach to the application of these rules, and I'll continue. Facts indicating the defendant's ties to the community, including family ties and relationships and length of residence. And then the catch-all, any other facts bearing on the risk of non-appearance or danger to the public. Now that's a healthy list for every arraignment that we have to go through. And I can tell you that I've sworn to uphold the laws of the state, and I do this when I examine people on the issue of arraignment and setting of bail. But that's a comprehensive list of the factors outside murder or treason, kidnapping, or CFC 1 involving kidnapping. Those are the non-bailable offenses, but everything else, there's a presumption you get a PR bond unless you go through those factors and weigh one more than the other, but you have to consider those. So I hope that gives you a comprehensive explanation of the process of setting bail or bond. Does that answer your question?
Yeah, sure, thank you. Mr. Catalino, do you want to say, would it be good if your office or you were there, able to be there to defend someone at arraignment? And, you know, since you currently tend not to be there, what consequences do you see currently?
Sure. Well, when I was in private practice, if I was retained prior to an arraignment, I would always go to an arraignment. I think the arraignment is probably one of the most important hearings that you're going to have in the entire process. I mean, many clients want to know, when can I get out? And it's not necessarily when can I get out to go commit other crimes. It's when can I get out? I got to go back to work. I got to do something. And, you know, the majority of misdemeanor cases are going to be fairly nonviolent or not as serious as, say, murder and treason and all those other ones that we see in felony court. So many people have made stupid choices, you know, made a stupid mistake, on what they go with their day, but try not to lose a job, those sorts of things. I often cite the court rule talking about you start from the proposition that you are guaranteed a PR bond and then move from there if there's other factors. It just always boggles my mind, and I don't know if this is a little off topic, but it always boggles my mind. If $25,000 cash surety or 10% of that, so if you can post $2,500, how does that protect you any better than a PR bond? It boggles my mind, because if I say to you, you make $100,000 a year and $25,000, 10% of that you got to post to get out, protects the public, and I say that same thing to a person who makes $15,000 a year, you end up with one person out, which apparently was what you were trying to protect against, and one person in. It's just the poor person stays. So the arraignment process, to make those arguments, I think is probably the most important place to start. I mean, it's the time. If you don't get somebody out there, the likelihood from just a institutional perspective is, at least in my experience, has been, well, you can address that with the next judge who will be assigned to the case. Well, we are by nature, that next judge says, Well, there was a reason the first judge assigned that bail or bond to that person for that reason, so I'm not going to screw around with it unless you got something else that is really, really important or really, really good. So, you know, that first judge, no matter what, is probably outcome determinative is as it relates to the idea of setting a person up for a ride through the system, I guess is the best way to put it. You know, would it be beneficial for our office to be there? Yeah, 100%, without a doubt. We have talked about trying to hire an attorney who's dedicated only to doing arraignments, start at 6 in the morning, get to the jail, meet with people prior to that, and then, you know, do the arraignments throughout the day, leave at 2:30, 3 o'clock, start that process again in the morning. I'm not sure I want that job. I don't know if I'd be qualified to be there at 6 in the morning, but but you know, the other portion of this is you know, Mr. Hilson's office, the public defender's office, Health West, wastewater treatment, we're all fighting for the same dollars. I mean, there's only so many dollars that are there. And the really hard part about that is if your toilet doesn't flush, that's really bad, right? You want money spent on wastewater and those sorts of things. You don't want criminals in your neighborhood, right? Nobody wants to live in a neighborhood where somebody's shooting up your neighborhood or doing those things, right? So we spend a lot of money on law enforcement. It's much more popular to give to Mr. Hilson's office, and I don't mean that in a bad way or a condescending way. I mean, yeah, I don't want, you know, violence in my neighborhood with my kids. So we spend a lot of money on criminal enforcement, the enforcement of criminal laws. So it's not excruciatingly popular to say, hey, public defender's office, here's another $100,000 to hire somebody to try to get criminals out. It's not a popular opinion, and you know, it's not a popular thing to do if you're a county commissioner to put money into that program and do those sorts of things. So what we have done is kind of try to help with some of this. We started an internship program, a social work internship program at our office, where we have master level and bachelor level interns coming in, and we have them meet after the arraignment. And part, I guess I should explain too, is that part of it is the public defender's office isn't appointed till after an arraignment is done. That's the, I don't know when the determination of indigency is made, but it's sometime either arraignment time or right before arraignment time. So I guess we don't get an appointment, so we can't formally represent anybody till after that appointment. So that is it during arraignment? During arraignment. Gotcha. So I mean, you know, there would have to be some tweaking to the system in order to kind of facilitate us being at that arraignment. But yeah, I think that's probably, you know, the money issues that go along with that, and Mr. Hilson and I, you know, our office having some of those same pot of money and those sorts of things are big and problematic. So,
Ms. Garretson, put it that way. Sorry, I said Heather earlier. But anyways, so I wondered if you could say, follow up on what was just said, and what type of people end up being in jail due to bond?
Poor. That's just the way it is. The judge did a great job of reading what the court rule is, and as a former law professor, like, that's what we teach people to do. That's how it reads. That's not how it works. There's very little data kept around the state. In Muskegon County, 78% of people in their county jail are pretrial detainees. I mean, that's just the numbers. In Kent County, 31% of people in their jails are pretrial detainees. I mean, I don't think that's because the judges in Nuevo apply those rules any differently, or look any differently at those rules. It's because we don't have a unified system in Michigan. Some courts use risk assessments, some courts don't. Some courts have a fee structure. Robbery, $500. Larceny, some courts have lawyers, some courts don't. I mean, it's just because that is the rule, that's not how it's applied. In Michigan, 41% of people who stay in jails, county jails, have not been found guilty of anything. So So when you're talking about the way it should work and the way it does work, what happens is the lowest third of the income, which is a medium income of $15,000 a year or less, are the people who are incarcerated pre-trial. I mean, that's just how the data falls out. There is a ton of work being done by the Criminal Justice Policy Commission, being done by the governor's office to try and figure out, like, how do we start capturing this data in a way that means something, right? So that Kent County does an amazing job of capturing the data, and they have a risk assessment tool, and it gives you a score based on all of these things, and they say to the judge, this woman is a risk 1, and that means really low, and so, you know, that would score on this, and this is why, and they take all those things into effect. Other counties don't have that. And so the counties that have it tend to have a little more uniformity in the application of the court rules. But again, that risk assessment, to be effective, has to be done before arraignment, right? Right, by pretrial?
No, it's done before arraignment. We get those risk assessments, exactly what you're saying, with a score and a grid and the person's substance abuse history and the criminal history and even there's a box that says other, and it gives the assessor like 4 or 5 lines to tell the arraigning judge, you know, some relevant things about this. Like, yeah, he's been living with his mother for the last 6 months and has been through a rehab program in the last 3 months. You know, so that just real relevant factors that I think are very pertinent. And through the Department of Community Corrections, Muskegon County now has utilized that risk assessment, and I think those folks are being there, Mr. Catalino, I think at 6 a.m., just what you said, and they're looking at the arraignments for that day.
So, and that's part of nationwide best practices. Like Washington, D.C. has moved to an almost totally cash-free bond system. 90% of their pretrial detainees are risk assessment, go, personal recognizance. 98% of the people they let go do not commit violent crimes until, they don't, before their original case they were arrested for is resolved. But they do it based on risk assessment. They have a very integrated tool that says to the judge, here's how you know if they are a danger, and here's how you know if there's a flight risk, which takes money out of the equation. But speaking of money, I want to go back to what Chad said about, everybody, if you want to have attorneys at the arraignment, that costs money. But I really think to have a conversation about this, you have to think in a much broader way. Like, it also costs money to keep people in jail. It costs $500,000 a day in Michigan to put people who have not been found guilty of anything behind bars. So, that's not free, right? And frankly, I work with law enforcement all the time. I'm a former federal prosecutor. I know sheriffs say to me, I don't want to run a mental institution here, right? We are not trying to have, when you talk about you have to consider mental illness as one of the considerations, then the thought is, to what end? If that person has serious mental illness, is jail where that person should, is that good for anyone in the community? The jails don't want that. You?
Could I just add something as well?
Go ahead.
In the DSM-5, substance abuse is a mental illness. So that includes cocaine, heroin, marijuana, and alcohol.
So I think we need to think a little bit more broadly about what law enforcement wants, right? Sheriffs want to have a population that they can properly control, and that where everyone in that population is safe. And frankly, that often doesn't include people with mental illness. So the money issue is one thing, but really thinking more broadly about what is the purpose of bail? What are we trying to do? And if it's to keep the community safe and to make sure people don't flee, is putting $2,500 on a robbery the way to do it?
One quick follow-up on that. Some people might say, well, no, it doesn't cost $500,000 because we charge them for being in prison.
Yeah, so I'm sure
Or
actually, Mr. Hilson, you could probably speak to that. All the data shows that the less likely you are to pay, the more likely you are to have fines, which costs more to collect. It doesn't do any good to find people who can't pay and then to charge them interest on debts that they won't pay. That's just not an efficient, and frankly, prosecutors' offices don't want to spend their time running those people down, because the reason they haven't paid is because they don't have any money, right?
Okay, yeah, so very little of those fees and tickets are paid, right? Prosecutor Hilson. I wondered if you want
I thought I
to.
was forgotten over here.
Yeah,
I was
yeah.
enjoying. I was listening to the conversation. It was
Yeah.
very, very good. Yes, sir.
One of the things that happens then within our system is a plea bargain. Most cases don't go to trial. In fact, maybe you can tell us how many are plea bargain compared to how many go to trial. And does the factor of whether someone is in jail or not affect how you might consider prosecuting a case in terms of whether it's a plea bargain or not?
Not necessarily. I mean, a lot of times, whether, depending on how much time a person has served in jail may factor in, because in Muskegon County anyways, and I'll speak at both felony and misdemeanor level, but mostly felony levels, there's always a conversation with the prosecutor, defense attorney, in looking at getting a sentence committed. We call it a COBS hearing, off of people versus COBS. And I won't go into the law school lesson of it, but it essentially gives the court the ability to commit to a sentence ahead of a plea. And that is a tool used to help move cases through the system. And so whether or not somebody has spent time in jail prior to that might factor into a judge's decision as to what sentence they might promise the defendant or defense lawyer. How that affects us in plea bargaining, I'm going back from my experience when I was an assistant prosecutor, whether or not anybody was sitting in jail, I suppose, depending on the level of offense, if it was a offense that was a low-level felony offense, time served sentence might be appropriate, and if they've spent 2 or 3 months in jail up to that point, by the time we get to the pretrial, that might be enough, and essentially would get a plea in.
I think one of the concerns is I'm sitting in jail. I want out, so I'm going to take whatever you give me.
Well, that's not my decision to make. That's the decision between the defense and their client. I don't take part in that conversation. I've never used that as a piece of leverage or an advantage. That to me it would be almost unethical. But I don't engage. That's not my conversation to have. That's for them to have with their clients.
Okay.
From my standpoint, when I was an assistant, even as the elected, when we charge a case, we're charging it based on our belief in the evidence that we have in front of us that a crime was committed and this person committed that crime. We start at the probable cause level, and ultimately, if we have to try the case, it's beyond a reasonable doubt standard, and we essentially carry that forward throughout the entire process. Whether or not that individual feels like they didn't do it, or that's what trials are all about. And trials are free. That doesn't cost anybody any money.
What percentage of cases go to trial?
District court, boy, I don't know. I mean, quite a few. District court runs Monday through Friday, and their bench trials are pretty common in district court. I'd say my assistants, when they go down to district court, they're carrying with them anywhere from 20 to 25 files a day. And maybe half of those are trials, and maybe half aren't. It just depends. At the felony level, the file number is about the same. We try, I don't know, I think over the last couple of years, we've probably averaged about 20 felony trials a year. Chad, I don't know if you've got a better number than that than I do, but it's on average, it's about that. So most of the cases in circuit court are ending up pleading out. They're resolving in some fashion. We don't try too many cases in circuit court. District court, it's a free-for-all.
It's just some national statistics. In federal cases, 97% are plea deals.
I don't work in federal court.
Right. I know. But in state cases, it's 94%. So.
So can I speak to that for a second? So DJ is speaking from a prosecutor standpoint, and they really don't have anything, like they literally don't have a dog in this hunt, right? Because they are just, they have somebody who's there and they are going to continue with the pretrial, and then if they don't plead guilty, they're going to go to trial, right? This is this bail is an issue that is almost completely separate from the prosecutor's decisions, because most prosecutors, if you say, all right, I'll give you a deal, it's time served, it's not so that you take the deal, it's because you look at the offense and you go, oh, you'd probably get 3 months for this, you've served 3 months, so that makes sense, right?
Yeah.
It comes in before the prosecutor usually because of human nature and the exact point you talked about. Like all of the national data says people are likely to take a plea that results in a criminal conviction if they are detained because they want to go home. If you are home and you are home and you're working or you're living at your mom's and you're eating your own food and you don't have to bunk with a bunch of strangers, and the prosecutor offers you a criminal plea to resolve it, you are less likely to do that because resolving it is not your first priority. I mean, that's where that comes in. It's not like it's used as leverage as much as when you are inside, you make different decisions, and they are usually based on not being inside.
Do you think that's right, Mr. Catalino?
I would suggest that my clients make decisions, who are incarcerated, make decisions, and one of the factors is, I want to get out of jail. I think that is a legitimate statement. I don't know the data. I'm just a low-level, like, country lawyer, so I don't know these data. That's hard for me. But the reality of my client's situation is, yeah, I mean, I'm sitting in jail. Obviously, I want to get out. Obviously, there's so many different factors to that too. I want to get out. I need to see my kids. I want to get out. I need to have a relationship, rebuild the relationship with my girlfriend, who's probably my lifeline to a house or an apartment or something of that nature, because I don't know where I'm going to go. I need to get to the mission because I left all my stuff there and I'm leaving. If they kick me out of the mission, all my stuff's getting put out in the dumpster and everybody's going to go through it and I'm going to lose everything that I have. Yeah, I think that's a legitimate statement. Now, the other interesting part about this is, my job is to present offers to the client, have a discussion with them about the pros and cons of those offers, what it is that they can do, what are the alternatives, are there other things that are available to them, and what they want to accomplish. I always ask my clients, what's your number one goal, what's your number two goal, and then have them make decisions based on those. Have clients made decisions because their number one goal is to get out? Yeah, absolutely. Is it somewhat coercive because they're sitting in jail? I think we can all say, yeah, you probably make a better decision if you're not under that coercion. But, is there a and I don't mean coercion in the sense of as a harsh tactic or anything of that nature. I just mean your circumstances will always dictate the decisions that you're making. So, yeah, my clients make those decisions.
I had a friend who had a job like yours as a public defender, and she didn't like it so much because she said she was, as it was brought up, overwhelmed, and said, I don't know, I feel like I spend most of my time convincing my clients to plea because I don't have time to really defend them. And so I'm trying to get them the best deal they can get, but also there's no way I could try all these cases. So I'm really just trying to arrange for plea deals. Do you feel that pressure? And I've heard this from others as well. Is it a tough job given your caseload?
Yeah, absolutely. It's a tough job. But DJ's job is tough. Their caseload is high. If you're a pretty decent private practice attorney, your caseload's going to be high. The nature of what we do is high volume because, first of all, if you're in private practice and you don't do high volume, you're not going to make any money and you can't keep your business going. But from my standpoint, I will say this. I don't treat this job any different than I did when I was in private practice. None. I do it the exact same way, and I will always do that. Now, I think that there is some realism to the idea. I tried, I think last year alone, I tried 8 felony cases, 2 of them being murders, and which, take up a lot of extra time. But I think there's about 1,800 cases per judge per district court for the public defender's office per misdemeanor, somewhere around there. Yeah, you can't try 1,800 cases in a year. There's no way. There's zero way to do that. But the reality is that many of our clients also are not unsophisticated in the system, I guess is the best way. And so they know that there's a potentiality for them to serve a little time or pay a little fine and move on. Now, you know, is it disproportionate poor to rich or better off in my, you know, in my experience? Yeah, because I represent indigent people, so I can't speak to the other portions of those things.
Judge Kostrzewa, as being a judge, do you see a difference between people who get public defense and those who have a lawyer on retainer? And that's one quick question, I guess, because I remember being on a jury once. We were deliberating, and someone said, "I don't know, that wasn't much of a defense. You think that was a public defender?" No offense. That's just what was said. But yeah. And then someone said, "No, I think they hired this person." And they said, "Well, if they hired him, there must not be a case there." Yeah. I mean, are those things considered about how, you know, how much resources do you have in order to defend yourself?
So let me clarify your question, and I want to be clear that I'm answering the right question. Are you asking me, in my opinion, from a judicial standpoint, is there a difference in the level or the effectiveness of a defense presented by a public defender versus the level or the effectiveness of the defense presented by a retained, hired lawyer?
Yes.
I can tell you this, that since from the beginning of my career in this system as a lawyer and now from a judge, I have heard, and I know Mr. CATALINO's probably heard this, and my colleague here to my left, Heather, has heard this, but when a person is dealing with the issue of they're indigent and they need a lawyer, I've heard this, "Oh, I'm getting a public defender. I want a real lawyer." And I kind of looked at that throughout the course of my career as not very fair. In this sense, the public defenders that I worked with as a prosecutor and now that I see in my courtroom as a judge are hardworking, good lawyers. I can name a number of lawyers in Mr. CATALINO's office, him namely one of them, who is a very effective lawyer. He was an effective lawyer as a retained lawyer before the public defender's office was of its nature in Muskegon County, because previously we had a contract system where individual lawyers were contracted through the court system to be public defenders, and now we have an actual real public defender's office with hierarchy, a chief public defender and supervisors who take responsibility for other lawyers' actions, oversee them, mentor them. I mean, it's a much more effective system now than it was before. But Mr. CATALINO and his colleagues are very good at their job. You know, with experience, you get knowledge and skill, and they have it. So I always thought it was very unfair for a defendant to say, "I want a real lawyer, not a public defender." I mean, Joe Fisher in the public defender's office is a phenomenally good defense lawyer. I've tried cases against him. I've seen him try cases in front of me. I would hire that guy tomorrow if I needed a lawyer. Mr. CATALINO, I would do the same thing. And I can name off many other lawyers. So I don't think that's very fair. I bet you Mr. Hilson, from his experience, would echo what I said. Now, listen, in every area of expertise, lawyers included, some are better than others. You get that in the medical community. I mean, there are some doctors, they've passed the boards and they can practice medicine, but just to be frank with you, some are better than others. I mean, engineers, professors, right?
Yeah, right.
Some are better than others.
I don't know that. They're not.
Yeah. So, I mean, that's the nature of the human condition, right?
Just this week, 60 Minutes had a program on this. And it's not that they're not good, the public defenders, it's just that they're overworked, and they said, "I don't have the time to look into this case like someone who could hire an attorney to spend that time."
And maybe, just maybe, they look at the facts and say, our best course of action in this case is to try to get a resolution to this case that minimizes your criminal liability. That might be an evaluation that's made too. I would bet Mr. CATALINO says that often.
Yeah, I always evaluate.
Yes. I mean, evaluate the strength of the case. Do we have a good triable issue? If we don't, we need to talk about how we can resolve your case. If we've got a good triable issue, now let's evaluate how strong that issue is. What's our likelihood of prevailing at trial? I mean, those are just fundamental criminal defense lawyer, analyses that must be made. And I trust these folks that they're doing it all the time.
I have one question that I want to turn to the audience.
I want to address that just real briefly, though. I think I agree with the judge, and I think that the majority of my colleagues across the nation try to do that. I really do. I think the bigger point, though, is if you're in jail, your analysis of, not the lawyer's analysis, the client's analysis of the strength of their position is maybe clouded some and tinged with, I want to get out. And I think part of the fear is, and some of my experience has been, is it's easier for people with money to avoid that tinge, which then allows them a better chance to have either a trial that they really wanted or something of that nature. So I agree 100% that most of my colleagues, most of the retained defense bar, prosecutors, judges, everybody's working really hard to try to do that and make those analyses and do those things in the right way. It's just that some of the people's, anywhere you're at, if you run out of gas on the side of the road and you see a gas station and you see a McDonald's, your decision making is to go to the gas station over the McDonald's, even though you're really hungry because you got to get the gas to go on the day. It's no different than when you're sitting in jail. I'm going to make a decision based on the circumstances.
So can I just follow up with that really quickly about perspective? So it's the client's perspective, right? Like if I'm sitting in jail, my decision making will be a little bit different. But it's also the jury's perspective and the judge's perspective. Because the nationwide data will say that people who are inside and they are sentenced with shackles and an orange suit get a longer sentence than somebody who's sentenced with a suit. And jurors, and I will tell you this, when I was a criminal defense attorney, we would shine up our criminal defendant clients. They didn't look a thing like their mugshot. In fact, we wouldn't put them on the stand because we know they would introduce their mugshot. But as a prosecutor, when I did that work as well, we would anticipate that by the criminal defense bar. So everyone's perspective is impacted when someone is detained pretrial. People who sentence that person, people who decide that person's guilt. I mean, what you are seeing makes a difference. And so if bail is intended to keep society safe and to keep people from fleeing, is cash bail the best way to do that? Because we know when people can't pay cash bail, there's sort of this cascading unintended consequences that happens for them when they go through the criminal justice system.
I want to clarify one thing, and I'm sure it was not intended, but it's a defendant that comes in front of a jury, the finder of fact, that you have that constitutional right to, they are entitled to be dressed in civilian clothing. They are entitled to not have shackles on their wrists. They're entitled to a presentation that does not allow the jury to factor in whether that person is a pretrial detainee or whether they posted bail. I know that we've taken great pains, delayed many trials to make sure that this defendant has civilian clothing on, that this defendant is not in shackles, that the jury is not basing a decision on pretrial detainment. And in fact, that is such an important point that even on our dockets, we hide the fact of bail or bond issue. That's not on the docket any longer. I mean, it was an issue. Because I remember on the old dockets, maybe 15, 20 years ago, you'd have a criminal docket posted in the courthouse, and it would say the whole plethora of criminal cases that are going to be heard that day, and one of the columns was jail or bond. Well, anybody walking in the courthouse is going to see that person's in jail or on bond. We changed that so that it's not a factor that the jury, the decider of the facts, knows. That's an important. No, that's a very important point. That's That's United States Supreme Court law. It applies across every state in the union.
Okay, so that's for the jury, but not necessarily for the judge, is that right?
Well, the judge is going to know the bond and bail because we've been involved in the case since the beginning. Absolutely, the judge knows bail or bond. But in terms of, and I just want to clarify, the decider of facts do not know, and by design do not know, whether this person is jailed, pretrial detention, or on
Okay,
bond.
thank you. I have just some quick things. Probably won't be quick, but you know I tried. I'm going to read through some recommendations from the Prison Policy Institute. I want to see if you all, just by yes or no, agree with these recommendations. Now we're talking about, these are from the Prison Policy Institute.
What are they?
It's a group, maybe Heather.
Yeah, it's a nationwide think tank, and they do a lot of data collection.
Right. You can, I think it's just prison policy. Yeah. One is eliminate the use of money bail. As I think Heather said, D.C. and Kentucky have already done this to a large extent. Would you all agree to that?
On the fence on that.
On the fence?
I think it only works if you have a good substitute, though, because DC and Kentucky did it with the risk assessment tool, right? So you're saying, we're trying to accomplish keeping society safe and making sure people
Okay.
don't flee. We're just doing it in a different way, and that works.
Okay, good, good. How about stop locking up people for not paying fees and fines?
That's a whole nother issue, right? We've been talking about bail and bond and how that should be set and what factors and whether we should use evidence-based practices and whether we should base it on, you know, a set of guidelines that are reliable, you know, and as I said, evidence-based. That's a different issue. Failing to pay fines and costs and fees, that's what we're talking post-sentence failing.
Right,
Is that what you're
right.
talking about?
Yeah,
Yeah,
yeah.
that's another real ability to pay issue for which we've got pretty firm law that applies across the country on. So your question on that is what?
Should we stop locking up people who
We-
can't pay their fees and fines?
Well, we must. We must. The law says we must. Bearden versus Georgia.
Okay,
It's a 1983, so we're not talking, you know, fresh off the mill here. This is a 1983 Supreme Court decision decided and opined upon by Justice O'Connor. She wrote a very, very well-written opinion, easily to understand. You don't need to be a lawyer to read it. I suggest you read it if you want to know what the law is.
That case says essentially that a judge like yourself needs to figure out if the person can pay or not, and if they can't pay, then they can't be put into jail for that. But if they can,
Oversimplifying it, but it's
Okay.
It's
all right.
it's
Well,
part of the
feel free.
analysis.
So how do you go through making sure I can pay or not? I mean, do you just ask me if I can, or is there a whole large assessment that goes into that?
It's question and answer from the.
Because I might
from
tell
the
you
judge
I
stand.
want to pay because I don't want to be in jail, or I don't want to.
You might tell me what?
I might tell you I can pay, but it's not really that I can.
Well, if you read this case, it strikes a very nice balance from the Supreme Court between ability to pay and employability. Do you have a job? Are you able to work? Do you have other resources? Can you borrow money, they talk about? Can you, to pay your fines and costs and fees? Because routinely, from the bench, I hear criminal defense lawyers say, Judge, this is a fines and costs case only. Do not incarcerate, don't use all the other or any of the other options you have as a sentencing mechanism. This is a fines and costs case only. And routinely we agree with that and assess just fines and costs for a criminal offense. And Bearden versus Georgia, Michigan procedural law requires a judge to make an analysis on the ability to pay before we incarcerate. Now, that's at the time of sentencing. We get an argument from the defense counsel, and this is a fines and costs case only. That implies, in their argument, that this person would rather pay fines and costs than do jail, or this person would rather pay fines and costs than do home tether. This person rather would pay fines and costs than go to a, inpatient substance abuse, rehabilitative program, or any of the other options that you can think of. So then in a year when the court gets the file back and they've paid nothing on fines and costs, now you've got to make an analysis. Do they have the ability to pay? So, I mean, it's common sense. Mr. Wible, you've got to ask the person, do you have a job? What's your employment history? When did you last work? Are you able to work? Do you have a disability that prevents you from working? Do you have a car? What are your assets? Do you have a car, a snowmobile, a four-wheeler, and a boat, but you don't have the ability to pay? I mean, do you have a cell phone that you are paying for yourself? Because you've made a decision. Now look, you've got to understand that this is post-sentence. This person's been convicted of a crime. Something needs to happen. The court has to enforce its orders somehow. So you make common sense decisions. Bearden versus Georgia says use common sense and reason when you make this analysis. And I can't think of another way other than to ask the defendant those questions.
I guess the concern is that often the defendants are in a vulnerable situation, and that makes their answers...
How so?
Because they're worried about not wanting to go to jail.
No one wants to go to jail. But if this is your 10th retail
they're
fraud,
wanting to make you happy.
I don't know about that. They may. You can laugh. I deal with cases all day where I get requests.
Do you think a cell phone is a luxury?
No. I think if someone is paying for their own cell phone, it's a factor that I say, 10 years ago. Can I answer your question? Okay. What I'm saying is that if someone has committed a criminal offense, keep a lid on this, folks. I'm going to try to rationally respond to you. I get what you're saying. I couldn't function without my cell phone today. 10 years ago, I did. I functioned just fine without a cell phone. I mean, I got through life fine. You may think it's a necessity, but it's one of those things that if you commit a criminal offense, you've got a lawyer saying, hey, don't do anything else to this person other than assess fines and costs. I mean, there's got to be some payment of your debt to society. You're shaking your head no? Then that's your opinion.
I had that 10 years ago, people had landlines. People don't have landlines anymore.
I do.
I knew it. Of course you do. One is that people don't have reliable places to live. They can't afford landlines, and they can't qualify for them. That cell phone, which you might, oh my gosh, your kids have cell phones. That's their computer. That's their way to find out whether or not what their work schedule is. Because they don't have a regular work schedule. They get called in at all different times. They might close the Starbucks that night and have to open it the next morning at 4 a.m. Okay? We're talking about the reality, not 10 years ago, but the reality now, and people need cell phones. And not everybody has a fancy, the newest iPhone. And guess what? When you're living in a difficult situation and circumstances that are beyond your control, sometimes that cell phone gets damaged and lost, and you can't always negotiate the best rate for that. But that is your way to communicate, not just with your friends and family, but with your job to try and find housing if you're homeless. And this idea that cell phones are some kind of luxury, again, that's 10 years ago.
Okay. And I respect your opinion, but I'm dealing with the whole package, and it's one question I may ask. It's not the end all. It's one question that I have to ask. And what I often hear is I need my cell phone for work. I can't work without it. Then I make a different analysis then, right? Or if somebody says, I don't use my cell phone for work, and my girlfriend's paid for it for the last 6 months, and I can borrow money from my girlfriend to pay the $200 that is a fine and cost, then it's a different analysis, right? I mean, it really is. It's a reason and common sense analysis. I would invite you to read Georgia versus Bearden, or Bearden versus Georgia. I really would, because I think it's a well-written opinion, and it is the law in Michigan, and it's been recently codified in our court rules that we've got to make this analysis, and that's one of the things that was just an example I used. It's not the end-all, be-all, okay? I mean, I try to base it on all the factors that are in front of me, and I can't think of any other better way to do it than talk to the person. If you have another suggestion on how to glean and ascertain this information other than ask some questions and inquire,
And
we do rely on the defendant.
I know the ACLU is currently doing a lot of research on this topic to make sure that judges are consistently and effectively using that case in its entirety. So maybe there'll be some interesting data in the future we can draw on.
It's been around for decades now.
All right. I'll get right to you. One last thing I said, I'd read this list here. Last one, would you be in favor of eliminating pay-to-stay programs for jail, that you have to pay for your time in jail, as well as reduce the costs of...
So, sorry, I didn't even know that was a thing. But, so some counties will send you a bill, right, when you go home. And DJ, do we do that in Muskegon?
I don't know if they send bills. I know at one point in time there was an effort to try to do some collection because the sheriff's department they're owed over almost $2 million in past debt, and that has since kind of gone by the wayside. So honestly, I don't know what happens when they walk out, the door, because I'm not a part of that.
There's still collections going on as it relates to your jail stay. In fact, I think it's submitted as part of the collections on the what is it, the third floor? I think there it's added to that collections agreement.
Okay.
Yeah.
So I think from a research perspective, that's just a numbers issue, right? If you have a collections department and it costs you more to collect than it does for what you're collecting, that doesn't make any kind of sense. So, I mean, it just financially isn't a good idea. So there are other counties. There's a county in Florida that closed their collections department.
They did.
Because it just costs too much to go after people who can't pay. Like, if the point of pay to stay is, I mean, what is the point of pay to stay? That you've committed a crime and so you have to financially support yourself in a system that has told you where to live? I mean, maybe there's a better way to do that where you would charge people who can pay but not end up using your law enforcement resources to go to a collections department to people who can't pay. So I would think you would make that decision. I mean, you could make it on morals if you wanted, but just run the numbers. It usually costs more to try and collect than it does to not.
Would you add to that as well? Phone calls being, very expensive, and our new prison, I know you have to do the video conferencing, and they charge you for that. So, I mean, it becomes very expensive to be in jail, and then often people who are in jail are poor. So, does it make it even worse? Any thoughts from the? All right. I can just go to the. I'll go to the audience. I saw one thing here.
Thank you, Dr. Wible. I was actually cheating and looking at my cell phone, but I was actually blown away, and I was sharing it with my lawyer friend here. We found a 2012 NPR report and 2 Free Press reports from 2016. Michigan ranked among the worst in terms of pay, no offense to Mr. Catalino, in terms of funding for public defenders. So this was Free Press and a state commission that talked about, so we have one of the lowest funding for public defenders. I'd love for people to address that. I just discovered that right now.
Well, that's why they had the Indigent Defense Commission. I mean, that's why that state commission was formed, quite frankly. And now it's on the state to come up with the money. Because ultimately, what has been talked about, these guidelines that they want to implement, that doesn't happen unless Lansing comes up with the money to fund it. Because the county, well, I mean, this is politics now, so you're not going to dump it on counties, because counties are going to wait a sec. You can't do that to us. And so the state has to come up with the cash. So where that's going to come from, that's up for those folks in Lansing to figure out. But that's the reason why the commission was formed in the first place.
I mean, maybe just follow up for Prosecutor Hilson. It's a political thing, but then I guess we do have the public issue of, is there injustice being carried out, and I believe the commission said, what was it? Words to the effect of routinely the poor were underserved in justice, and then that seems to be a big issue. And I'd
Listen,
love to hear.
I don't listen. I was when the public defender's office here in Muskegon County was first proposed. I was the first person to jump on board and say yes, do it, because the system that we had before, and I worked in that system, was okay. But I personally felt, and those are colleagues of mine, but I understood they were balancing private practice and public practice. You can't do that. So I praised the fact that Muskegon County was going to be one of the first, besides Washtenaw, to do this, and it's done us. We've been leaps and bounds. In fact, we've had the privilege of having 3 counties, I think, come visit us and wanting to hear how our system is modeled. And actually, Berrien County, as a result, has a public defender system now. I think Ottawa County is looking at it. I can't remember who the 3rd county is. Maybe up north.
And these are counties who are doing it without state money, right? Because
Yes, we're doing it without state money.
that's right. So they have taken it upon themselves to look at that report and to say, okay, we're going to fix it. But the state money is on the voters. I mean, if it's important to you that people who are accused of crimes in Detroit have a public defender, like, that's your legislator. And
Right.
so when we ask questions, when people go to the vote, like, are you tough on crime? I think if you start asking, are you smart on crime? That might be a better way to understand how to cast your vote.
I guess I'd challenge you in the sense of, are you willing to pay $3 more and I'm just making numbers up, but $3 more in gas tax or in property tax or in something that is specific to Muskegon County to help fund a public defender system? And if you are, great. Can you convince everybody to convince the commissioners to do that? Because quite frankly, and this is, I don't mean this to be insensitive, but if your neighborhood's getting shot up, you don't want somebody defending somebody to get them back out. You want Prosecutor Hilson and judges to be tough on that crime. Most of the public does not see the importance of what it is a defense attorney does, whether that person is retained or not. We don't defend individuals. What we do is we defend a system. Is the system working right? Did they charge him right? Did the judge do the right analysis on the bail or bond? Did the jury do the right thing in a sense of understanding the law and being instructed on the law and then making those decisions? So that when other people who are maybe in a different position than the person who shot up a neighborhood or are wrongfully accused, they get the benefit of that system working. So you gotta, if you're not going to change the framework of what you're thinking about and what we're trying to accomplish, that defense attorneys are really good for the system itself, you're never going to get, and I understand there's a broader issue as it relates to funding, but you're never going to get people to consider funding as being an important factor in doing that. And then you're never going to get lawyers who are having 5 cases a year or 20 cases a year and having more time to work each one of those cases to the nth degree.
Yeah, if I could just follow up real quick, and then do you think, given your experience and your work now as public defender, do you think that we could decrease the amount of people in jail and still provide protection to the public, given that a lot of people who are in jail are not a threat?
Well, that's pretty speculative.
Because Michigan decreased its jail population. It was at an all-time high at 50,000. It's now down to 43,000. MDOS.
Yeah. You're talking to DOC prison.
Time, violent offenses decreased. I mean, they just did. There's a million things that go into whether people commit violent crimes. But we have, as a state, decided that decreasing the population is something they're trying to do. And simultaneously, people who track it show that up to from 2012 to 2012, violent crimes also decreased. I mean, so we know it is not lockstep. The more incarceration, the less crime. And we know it's not lockstep to say the less incarceration, the more crime. So finding a balance for a safe society and a responsible justice system is rough. But you have to have skin in the game. Like, you have to vote for people who make wise decisions. You have to ask yourself, like, what makes your community safe?
No, I just wanted to add, and it kind of dovetails into what Gretchen just said, and what Heidi. Yeah, no, it's Heather. I apologize. It's the first time I met her. I'm terrible with names. Turn this around so I can read it. I need to see it. And Mr. CATALINO said, it's really about having confidence in your system. I mean, our whole system of justice is really just an idea. I mean, the Constitution and all the rules and everything that I read, and Georgia versus Beard, those are just, it's ink on paper unless people, our community has faith that the system is working, confidence in it, and they're willing to invest in it, both willing to sign on and say, I'm going to be there for court, I'm going to show up for jury duty, I'm going to participate in the system, but also on the issue of, am I willing to invest a few more dollars to make sure that the public defender system is working properly? Because when people have confidence that that's working properly, they have faith in the system. And I know it's idealistic to say that, but it really is fundamental that we have confidence that the system works. That's what the whole buy-in is.
Sure.
That's why we submit to it.
So if you could put your hands up, and I'll try to get to questions, and I'll start right here.
Okay, so you have a charge and you owe the fines, but because of that charge, you can't find a job. Okay, for instance, I know somebody who has a drunk driving. He did jail time for it, lost his license, mandatory AA meetings. How is he supposed to get to and from AA and job hunt? I mean, he borrowed the money to pay his court fines and his probation fines and stuff like that, but he needs a job to, how are you supposed to do that? I mean, I can't quit my job and my school career to transport him. His mom can't do it. How do you guys have suggestions? Are there court or public transportation?
Okay, so I think this is a two-part question, even though you don't know it is a two-part question. I guess I'd suggest. Yeah, your question is way different than what you just asked. No. The first part of this is a philosophical discussion. Are there responsibilities and are there consequences for criminal activity? And how far should those go? I think that's a legitimate public debate. And I may have a point, a position, other people may have different positions. I think that's an excellent public debate. There will always be consequences for those things. So I don't know the answer to that. And I don't know. Hopefully I'm bailing some of my colleagues out a little bit too. You're asking a philosophical question that I think is for the public to make that decision. As it relates to just specifics, I usually tell my clients, look, if you're out in the rural areas, can you get on a bus? No, you cannot get on a bus because the rural areas don't have buses. So now we have to be much more creative. Do you have access to rides from family, friends, those sorts of things? No, I don't have those either. All right. We need to figure out how we get to the nearest bus station or bus route. How far is that ride? How far is that on a foot? How far is that on bicycle? You got to be creative about those sorts of things. I think really good public defenders' offices, and mine included, quite frankly, are really trying to deal with some of those ancillary issues to help our clients to overcome those. And I'll tell you a quick aside. I had a client one time who had a really good deal worked out, really good deal on a felony case. And I want a trial. And I sent one of my social workers over to the jail because I could not figure out why she wanted this trial when there was a really nice deal worked out for her, and it would limit the amount of jail time. She wasn't going off to prison. She could stay close to family, those sorts of things. And it turned out that she had paid, she got a retirement account check from her deceased husband once a month, and she needed to pay the bill for her house. Otherwise, when she got out, the house would be gone and all her stuff would be gone, right? So that was the concern. So we drafted powers of attorneys. We recruited family members to make sure they were paying on a monthly basis, doing those types of things. So I think the public defender's office, and quite frankly, retained attorneys in Muskegon County are not doing that type of thing. That work they don't have that framework in place to do those types of things at this point in time. So we're trying to develop those types of things to help with those ancillary issues so that when the consequences come and the public says, yeah, we want consequences for crime, that those consequences are more easily dealt with from the ancillary perspective.
All right. I saw some more hands up. I'll go here.
So in regards to the fees, couldn't they just have some type of form that they would fill out that would be a general form for everybody across the board to figure out what they could pay for? Like, you have your mortgage, you have documentations with that, what your income is. Kind of like if you're going to DHS or any of those places, you need to prove that you're poor. Is there a way they could do that and then the fees be from that?
You know what I do is I go back in the file and I go to a form that really evaluates the person's indigency level for the appointment of a public defender. And there's a form that's designed so that the arraigning judge sees income level, employment history, assets, liabilities, and I go back to that. And I use that on my ability to pay analysis a lot of times because it's a signed statement that the person makes at the beginning of the case, and I use that as a starting spot and ask questions. So there is a form that we kind of examine those things. Another thing we use, and we're instructed by this Georgia, or Bearden versus Georgia case, and the law in Michigan now, we recently amended this, to look at alternatives to the pay or stay, where you can't pay your fines before you go to prison, and so we're not making it a debtor's prison. What's an alternative? Can we impose community service for all or a portion of the fines and costs? Do we set up a payment plan where we extend it over time? Where we say, okay, we know you can't pay the $600 today, but what if we stretch this out over a year?
Okay.
Can you do that?
Those things only work though when your community empowers them to work. So if there's great research on reentry programs that instead of giving a fine, say you have to do 200 hours of community service, but you have to have in your communities missions that are willing to have people with felonies come in and volunteer. You have to have school districts that say, if it's a check kiting charge, we don't care if you come in and help rake the leaves. Like, you have to empower people then to serve their hours, and you have to look at the barriers felons face in community service, right? And those are community decisions. Those are not law enforcement decisions. Those are not attorney decisions. So to think outside the box and take money out of the equation, I mean, money is too much part of the equation anyway, because it doesn't get us where we want to be. Fees, fines, and costs go to court, right? So that's how the courthouse turns on its lights. I mean, is that a good system? And if it's not, what are we willing to do to take the money out of it?
And we're constantly battling the funding units, whether it be the state or the county, to explain to them that the judicial system is not a cash cow. It might be a spin-off, ancillary effect of the system as an alternative to incarceration. We say, okay, we're going to give you fines, costs, and fees and restitution versus put you in jail. That's an ancillary byproduct of the system. It's not what we are designed to do. And we are constantly battling the funding units to say, listen, this is a separation of powers issue. The legislative branch of the government, they are the treasury. They have the purse, and they will fund the court system. But we have to constantly remind them, look, this is just a spin-off effect, the fact that there's fines and costs and fees and collections departments and things like that. We're trying to see that justice gets done. That's our job. And to keep reminding them of that is, it's a constant battle.
All right.
I think this is more of a statement than a question. If we go back to the original chart that Andy had shown, the correlation of the statistics of when you look at pre-1970s to today and the incarceration rates that we now have in this country, there's a direct correlation to the war on drugs. And I don't know if a lot of you are aware, but the 13th Amendment abolished slavery. But if you go back and actually read it, it abolished slavery with one exception, unless you're a criminal. And there's a wonderful documentary on Netflix done by Ava DuVernay, I think her name is, DuVernay, that talks to this issue and how we've turned our prison and incarceration system into a profit center. In Michigan alone, we had a fiasco with Aramark these last few years. They've now been pushed out of our system completely because of the illicit actions that have been done by that company, the amount of money that they're taking out of our system. You also have a lot of possibilities of corruption, even within our judicial system. In general, I agree with the judge that we have probably the best judicial system in the world. But because of our school to prison pipeline and the profit centers that have been created since the 1980s and the war on drugs, it does give the possibility of corruption. There was a judge in Pennsylvania that was incarcerated for doing exactly that, for sending children to a private prison of all places. And we now have a presidential administration that is bringing private prisons back in force. And thankfully the target today is not poor people, it's not people of color. Sadly, it's immigrants, it's Muslims, but it's affecting all of us. And so there was a wonderful statement that was made earlier is, the judicial system can only do so much. The people we really should have had on this panel come from a completely different branch of government. They're the ones that create the laws that our judicial system has to follow. What is the answer to that? I don't know that anybody on this panel has the answer to that. I applaud that all of you are here, and I applaud the steps that have been done both here locally and in some of the other scenarios that have been done. There's definitely work within the judicial system, but that's not who I see that is causing this problem.
Just to ask a question out of that, Prosecutor Hilson, no, it's good. It was good comments. But Prosecutor Hilson, have you set up, since you've been prosecutor, some alternatives to jail and prison?
Absolutely, yeah. I mean that's one of the couple of the things I'm most proud of. So I have in my office both a juvenile and adult diversion program, where those are pre-charge diversions. So when when police departments bring in warrant requests, instead of charging them, if the candidate is appropriate for that particular program, we divert it. So they're not charged. They don't even enter the system. I'm also very active in things like Project Exit. When we talk about reentry, a supporting person on Project Exit, which is basically taking men right now out of jail as they're serving, and they spend most of their day over at the Exit Center, which is the old jail actually on Pine Street, learning skills. They're being taught by MCC people, and they come here. And what's really cool is that program's been going on for about 2 years, and we're in the process of trying to extend that for another 2 years. I saw Kate here, if she's still here. There she is. Hopefully our future fiduciary of that program. We're seeing, and again, Muskegon County to be proud of this, of all the programs, and there's 16, right? Am I getting that right? 16 programs, exit programs. We are the best. We have the most people employed, over 50%, I think close to 60% of our gentlemen are employed. They're learning skills, and so the idea is making somebody better when they're in, making them better when they get out than compared to when they were in. So I'm a big fan of anything that is a diversionary, proactive, because, look, the cycling people through the system isn't fixing it. I get that. And so I'm always about figuring out ways that we can be more proactive, so that my philosophy is I want to make you better coming out than when you were in, and what program is going to do that, and how can I be involved not only at a local level but at a state level to ensure that kind of activity is going to happen in the future.
Do we have drug court currently? And
it's a great question. I actually led a group of many different individuals: Public Defender's Office, Judiciary, Health West. Who else was part of that? I can't remember all the players. We submitted federal money to essentially expand our sobriety court to bring a drug court to Muskegon, and we're still in the mix. Last I had heard, we had passed the initial screen, and we're still in the mix. So I'm keeping my fingers crossed that we're going to be able to get the federal dollars here to actually fund a drug court here in Muskegon. So,
expand on that. What you brought up is the whole specialty court issue, and it's another option that the system has as an alternative to incarceration. And the more options that we can have, the better the sentences are going to be, because they can be tailored for somebody's specific needs. Specialty courts are a great way to do that. I mean, the treatment model of a specialty court flips the whole criminal justice system's kind of punishment mode on its head, turns it over, and says, we're going to delay that a little bit here. Let's see what services you're entitled to as a veteran. We have a veterans treatment court here in Muskegon now. Let's see what services you're entitled to through the sobriety court system, both felony and misdemeanor level. We have a mental health treatment court now. We know the mental health system in Michigan is significantly failing. But I think the criminal justice system, by taking the bull by the horns and saying we can create a mental health court where somebody comes into the system because of a mental illness, let's set aside the punishment idea for a little bit and see if we can get this person plugged in through community mental health, through their family members or any other organizations, churches, social, civic groups, to help this person function daily. Maybe it's just to make sure that they get to their doctor's appointments and get the correct medication. And all of a sudden their life gets real stable and they quit committing crimes and they commit being involved in the justice system. And that saves everybody money, and you wouldn't believe how good it feels to see somebody after a year in one of those treatment courts saying, you know what, I've been clean from drugs and alcohol, or I've been on my meds for a year and I have had no contact with the system, and this has changed my life for the better. It makes me want to do my job every day.
The pipeline is maxed out. How do we decrease that back to pre-1970 statistics?
You've got to be thinking out of to do that. You've got to be thinking out of the box that punishment is an aspect of the criminal justice system, no question that is. But you've got to be thinking of other alternatives of what do we want to achieve here. You know, what do we want to achieve? And rehabilitation's one of them. And I think that the treatment courts, including a drug court, which I think we need desperately given the epidemic of heroin that's, going on right now, I think we need to have a drug court as well.
Okay, but thinking outside the box is even so much bigger than that. It's like changing the dialogue completely. So many people are in jail because so many people are arrested. Why are so many people arrested? Because we arrest more now than we used to. And when we arrest those people for charges that used to not be arrested, we charge them. That's more. When they go inside, they go in for longer, right? So it's this whole pipeline of more massive. There are movements for prosecutors who run on tough on crime, but here's, the three diversion courts. Here's how I have made your community safer. There are judges who are being scored by different community agencies on how many people that they don't bond out, right? Like, if you hold the people in the criminal justice system responsible to different standards, they will respond. If you say to an employer when you're interviewing for a job, are you a fair workplace? Do you hire people with records? Like, that's important to me before I'm your employee. Like, that drives different discussions, and that is what is a more organic change.
Good. Other question? All right, for a while here.
I have a question for Mr. Catalino. Judge Kostrzewa mentioned how he didn't notice a discrepancy in the work ethic between a public defender and a retained lawyer. What do you think leads to the negative perception for those public defenders?
Okay. I think this is a really complicated question, quite frankly. Number one, in any profession, you have people who work really, really hard, and you have people who do not work really, really hard. So, like last night, I had 27 felony hearings today. I went back to work at 6:30, worked till about 11:30, then did some prep work for this, then went home, slept for a couple hours, got up, was at court. That, to me, is the people that we need to and I don't want to use the term glorify, but to put out there as the model of people who are working. There are lawyers who do that on a daily basis, weekly basis, for no money, because they believe in the system, because they believe that what they do is really important. But nobody sees that. Now, the other portion of this, and I think it's somewhat anecdotal, or is that how you say it? But close enough. I'm tired, baby. I am tired. But yeah, exactly. But the other problem is, what happens? Who do you blame if? And this is a societal thing. How many people take responsibility for the crimes that they commit? Oh yeah, I did this, I did that, I did this. Yeah, that's easy. But how many people have been raised by single parents who have not been at home, who have had to work 3 jobs to keep food on the table for their kids? So those kids raised themselves, and who have always blamed somebody else. Well, I didn't get good grades because my mom was around. I didn't do this because somebody was there. Not everybody, but sometimes. So who is the person that's directed at? The guy that's telling them your case stinks. They have a confession from you. The police caught you running out of the building with the laptop in your hand, those sorts of things. So when you get that type of, hey, you're responsible. Now we're in consequence limit mode as opposed to trial mode, and we're trying to reduce the consequences here. But we are never going to try this case and win. Well, now you're not fighting for me. You don't do that. If I paid a real attorney, if I gave somebody real money, they'd tell me what I wanted to hear and that sort of thing. Yeah, of course they're going to tell you what you want. I can tell you, there are 14 lawyers lined up down the street that will tell you what you want to hear if you give them the right amount of money. Is it ethical? Is it that? I don't know. I mean, that's none of my business. All I know is that perception comes about because of those types of things. The other, and I tend to agree, everybody's kind of laughing up here, the name public defender, I can't tell you the number of times that I've had courts say, were you represented by an attorney during this? We do this plea proceeding where you get a habitual offender. You got to ask if they were represented by an attorney for certain purposes. And no, I wasn't represented by an attorney. I was represented by a public defender. Okay, well, I got my license out of the cracker box. That was a Cracker Jack thing. But I think that when you say, I tell everybody, I'm your attorney. I don't work for the prosecutor's office. I don't work for the government. I don't work for the judge. I don't work for anybody. I work for myself. And they pay me pretty well now. Quite frankly, I tell my clients, they pay me pretty well. I get a fairly good salary for doing this work. And it's stupid, but it instills some confidence. And oh, you're getting paid for this? Yeah, I'm getting paid for this. Yeah, I got to feed my family too, buddy. But but I think that's part of the problem overall. Now, at some point in time, you just got to have thick skin and deal with it and go on, though. With all of that being said, but there's the perception in Muskegon County, I believe, is changing. I really do. I think there are more of my clients understand, since they are represented by a law firm. That law firm is the public defender's office. There are 14 or 13, whatever it is, lawyers in that law firm. They have their own research department. They have social workers. They have, all of these things that are associated with these high power, investigators. Yeah, good point. So I think that perception is changing here in Muskegon County, and I think it has the possibility for being changed across the country, quite frankly.
We mentioned the 60 Minutes episode this Sunday where the City of New Orleans public defenders have said they won't take any more felony cases. They're so overwhelmed. And the chief public defender actually said he didn't have a choice because the criminal justice system in America is so broken. It's become just a criminal processing system. Now, Judge, you mentioned that we have to have faith the system is working, and I'd be really interested to hear what each of you feel about this gentleman's statement that America's justice system is broken and has become a criminal processing system. This is obviously someone who knows what he's talking about. Thank you.
Well, I don't know what I'm talking about. I'm just a country lawyer. I just get up in the morning, read the Constitution, pay attention to I read this e-journal, try to figure those stuff out. There is a philosophical discussion that you want to have. That's the point, right? That is the criminal justice system broken or not? There are those people who believe the criminal justice system is broken, and they believe it's broken because you can't process all the work. I don't have enough money to do all of those things. He didn't say he was taking, and you got to be very careful. He didn't say he wasn't taking any more cases. Any more felony cases. He said he was being careful on which felony cases he was taking because a murder case is much harder to process. A armed robbery case, a CSC case, is much harder to process. It requires a higher level of thought process and more time. That's what he said. He's still taking cases, and I know this for a fact because our office has been in contact with that office. So the reality is that you want to have this philosophical discussion about whether that's broken or not. There will never, ever, in my opinion, as long as you live, be enough time to sit down and try every single case ever known to man. Unless the police and everybody stops enforcing laws, there will never be that amount of time. So the question becomes, how much time? And is a plea agreement okay? And is a plea agreement philosophically okay? And my clients make decisions all the time based on that. Now, some of them, those decisions are harder and maybe are a little more coercive because they're sitting in jail. Or maybe they're more coercive because they can't pay certain fees or fines or costs or those sorts of things. But what you're asking is a philosophical, does somebody have the right to make that decision? And should they be making that decision? And are the lawyers that are involved in that and the judges that are involved in that cognizant of those things? I think we are cognizant of those things. Now, you come down and you give me $100,000, I'll hire 2 more lawyers. And those 2 more lawyers are, I'm telling you right now, I will hire them in my image, because that's the last person I hired was in my image, and they will work nonstop until they explode. Those are the people that I will hire. But nobody wants to give me $100,000 to hire 2 more lawyers. Nobody wants to give me $500,000 to hire 10 more lawyers to do those things. You don't want to pay that. That's the reality of the circumstance. And until those circumstances change, I don't think you can call it broken or fixed.
Heather, do you want to, I mean, given some of the statistics you gave and I put up, does that show that the system's broken, the racial disparities, the amount of people in jail and prison?
Here's what I think you can take away from the data. If you've read Brian Stevenson's book, Just Mercy, he says the opposite of justice in America is essentially, I mean, it's not, what determines justice is not innocence. He says it's wealth. And, there is a different outcome if you have money for our criminal justice system. To your point, right? If you have $100,000, I will hire 3 people. So the impact of money has an impact on justice. I mean, it just does. And I don't know how to change that, but that accounts for exactly what we're talking about. Who gets out on bond, who doesn't. What kind of community you live in, how is it policed? I mean, what kind of social safety net? Talking to your point, Judge, about there's a direct correlation in Michigan of closing the mental health facilities and increase in jails, right? And those people don't have money to get treatment. Like, yeah, so, I mean, this all comes back to cash, right? So that's what's broken.
Other question?
Okay, great. I just wanted to comment that the judge said a couple times right to trial, everybody has a right to trial, and then Mr. Hilson said trials are free. But I want to point out that if you're a working poor person and you don't qualify for somebody from Mr. Catalino's office and you have to pay your attorney, you're going to be paying $7,000 to $10,000 for a trial. You're going to have to pay a couple $1,000s for expert witnesses, and if you need 3 or 4 of them, that adds up. So if those people are working poor, those trials are not free, and it seems like with a trial you get a better outcome because all the details come out when they don't when you're just going in front of a judge.
Well, there are protections. I mean, people who are, when we talk about working poor, they can file, their lawyers can file for the court to pay for their expert witnesses. That's happened to me quite a few times, actually, where retained lawyers will say, listen, my client can't afford an expert witness and I need one. They file it and the court pays it. So there are mechanisms in place to do that. And I guess I probably spoke a little too quickly. Trials aren't free. I mean, we all know that. I mean, trials aren't free. I guess the choice is free, though. I mean, you can always, when people say to me, they'll say, well, what should I do? Or people come to me and say, what should I do? Well, we're paid to try cases. I mean, we're trial lawyers. And I totally believe in the trial system. And what I tell my assistants is, look, if justice requires a trial, regardless of the strength or weakness of the case, we're going to have a trial. I mean, that's what we paid, or that's what we signed up to do, essentially. It costs. I mean, it costs me. I mean, I've got a budget, so one of my line items in my budget is expert witnesses, and I can tell you that line item is very, very small. All right. And when we talk about caseloads and whatnot, he's got a caseload. Mine is double that, because not only is he working on the cases that we've charged for public defenders, but I also have all the retained lawyers. I also carry the burden of proof. So I've got an extra couple layers of things that my office does. But at the end of the day, when I decided to be an assistant prosecutor, it wasn't to make a lot of money. I knew I wasn't going to make a lot of money, but it was because I loved the work, and I wanted to serve the public. And that's why I take the certain stances that I do even as the elected prosecutor, because I think there are ways, just to get back to her point up there about the system being broken. I don't know that it's broken, but there are ways that I think we could put some Band-Aids on it to make it better than it is now. And for me, it's all about making sure that those Band-Aids don't put public safety at risk, right? Because we all want to live safe and quiet and free. And so that's a hard balance sometimes, but I do believe that there are a lot of things that we can do that doesn't put public safety at risk, that does keep folks who are charged or incarcerated, makes it fair for them. It's hard sometimes, even I catch myself when I start talking about that, because again, my job, the way I look at my job is not to put people away, not to incarcerate them to the max. It's to serve and bring justice. And justice is a lot of different things. If you go and you shoot somebody and you kill them, justice is one thing. But if you're addicted to heroin, cocaine, or whatever, and you're struggling with that, justice is something completely different. And so to me, that's a balance that I like to strike, and it's very easy to strike that. So I don't know, it was kind of a merry-go-round answer to your question, but
just to follow up on plea deals,
Yeah.
compared to going to trial.
Yeah.
Often someone's given a better deal than they would get if they went to trial. At least that's the way it's sometimes explained, a plea deal. So is that really justice? I mean, if you're saying, look, it's be wasting my time for this to go to trial, so let's do a plea deal.
I've never said it's going to waste my time.
But I mean, is that...
I've never said that, Andy. I don't know. Where do you get that?
No,
I've never said that. I'm going to waste my time going to trial, so I'm going to throw this deal at you. I've never said that.
I'm just wondering if that's the way people feel.
Absolutely not. No.
So why are you presenting a plea deal? Is it...
Well, when you have, every given year, you have 4,000 felony cases and 6,000 misdemeanors, as we've talked about. You can't try 4,000 felony cases. You can't try 6,000 misdemeanors. And so there's a give and take in the system between the prosecution, the government, if you will, and the defense lawyers. Defense lawyers know that we can't try 4,000 cases. And so we look at, okay, what's fair here? What's reasonable? What is going to serve justice? What, if it's a victim case, what is the victim, what's going to make this victim whole? And make them feel like the criminal justice system served them right. Or it's a defendant who has whatever circumstances. What's fair that, in other words, there's a consequence for their actions, but we're not, taking the hammer and banging them over the head at 500 times. So I guess I disagree with your assessment on that. I mean, when we talk about...
I'm just presenting what's often out there. So.
Well, it gets me fired up, as you can tell. But it's about reasonableness. I mean, quite honestly, it's what's fair and what's reasonable when it comes down to plea deals. And I haven't, at least, and I never tried to toot my own horn, but for the most part, throughout my entire career, I think people have classified me as being fair and reasonable, and that's the philosophy that I carry through in my office, or to my staff now that I've taken over. And so, I don't know, I mean, they may have a different experience, but in my career, and working with the folks here, it's always been kind of a give and take.
The fair and reasonable one, you might be right in your case, but some of the statistics seem to show that race, for example.
I can't speak for other. I can't speak for other philosophies.
Seems to be a factor.
I mean, for me, it's about how can I represent Muskegon County and the people of Muskegon County the best. That's my goal. That's my number one goal.
Does the office do work on overcoming bias and whatnot that we tend to have as a society?
Well, see, we've had this discussion in one of these other sessions.
I know, just bringing it up.
You trying to trip me up again or what?
No, I don't think so.
Look,
But
my career as me, and now as the boss, I have never, ever, 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 ever let race make a determination of what I do, ever. That doesn't happen in my office, and I think the last time I was here, I said if it ever did, and I found out about it, that person would be fired. I mean, it just it's never a factor, if you will, in how a case is resolved, how a case is charged, whether a person's getting diversion or not. it never plays.
What this guy here will teach me, though, has taught me, though, is that the concern is I say the same thing when I teach, but then I also realize I might have this implicit bias that gets in the way.
Listen, I don't see color. I just don't see color. I see right and wrong.
Yeah,
I don't
might
see
be
color.
right, but
Look, can I just want to add, I have the utmost respect for these two people. I think they do a fabulous job. I've never had a problem with either one having any sort of bias. You know where the bias comes in? It's at 3 o'clock in the afternoon, and you've heard the same story from the same defendant over and over and over again, and people are human. These two guys are human. Judge is human. You know, do you roll your eyes? I roll my eyes at my clients sometimes. Yeah, I've heard that 37 times today. Is that bias? Hell yeah, that's bias. Yeah, that's an absolute bias. It's not bias based on race. It's not bias based on economic problems or any of that other stuff. It's bias because I've heard that same thing and I've argued it 6 times today and it hasn't worked once. And now I'm perturbed. I got to go argue it again. Will I do it? Absolutely, absolutely, without a doubt. But I think that to suggest that there is a bias in race, charging decisions in Muskegon County, at least, I don't know that to be a fact. There may be other factors that play in. Are police officers racist? I don't know. Maybe some, maybe not. Are they patrolling neighborhoods where they're economically underprivileged? Probably so. But as it relates to the bias in the court, I haven't seen it here in Muskegon County, quite frankly.
I do have a question that is on another topic, and I know we're getting towards the end of time, but it won't sit well with me if I don't get some clarification on this. So a couple of times it has come up talking about murderers or justice and being tough on crime, and when I think Debtors Prison, that's not really what I think about, that we're talking about the question of if a murderer gets to just pay a fine and leave. My question is around, with this topic, a differentiation between our violent crimes and nonviolent crimes and the folks that are in our Muskegon County Jail. This might be a better question for our sheriff than perhaps the folks up here. But the people who are there who cannot afford to pay to leave, what are the crimes that they're being locked up for? Because I have a feeling it's not someone who has shot up a neighborhood or who is, I have a feeling that is not really the issue that we're talking about. And when it comes to protecting neighborhoods, I do think that's what everyone wants. And there's some research that does look at when in neighborhoods where incarceration is so concentrated and so many people have been pulled out of that neighborhood and put into a jail, it doesn't make the neighborhood more safe, it makes it less safe because people are not at home to work to support their spouse and their family. People become more desperate. People have less support in their home. And when that's concentrated in neighborhoods that are poor, it's actually less safe for us. So what are the crimes that are keeping people locked up and away from their family? Is it murderers or is it something else?
Well, that's a tough question to ask. I mean, we'd have to just go into the jail system and figure that out. But just in a general sense, I'll agree with you that for me, incarceration is never the first option. I mean, I think I've learned that pretty much early on in my career that we're not, because for the most part, whether it's prison or jail, those folks are coming back. Right, they're coming back into our neighborhoods. They're coming back into our county, and so we've got to do something more proactive to make them not become a product of the criminal justice system, if you will. And so that's why I believe in diversion. I have I do the diversion programs. That's why I do Project Exit. I do things with juvenile court through Project Fresh Start. It's all about figuring out alternative ways to show that there's a consequence, but also not, as I talked about before, cycling through the system. And so to directly answer your question, I'm not sure anybody up here can answer that question, because I don't even know. I mean, I can tell you a couple. Jeff Willis is in jail. He murdered some people. Allegedly.
I don't mean that to be funny. I mean,
yeah. He hasn't been convicted. I'm sorry.
So
I'm not arguing with you. I'm not debating that fact. What I'm saying is that there are different ways and alternative ways that we can handle some of these situations. But again, and I'm not gonna throw my judge friend here under the bus, but sentencing is a judge decision. It's not a prosecutor decision. It's not a defense lawyer decision. That's a judge decision. Now, we get a chance to advocate one way or the other, but ultimately it lands with the men and women that wear the black robes all over the country.
So for jurisdictions that keep risk assessment analysis, in Kent County, over 50% of people who are detained pretrial are non-violent, are accused of non-violent offenses. We don't have that data in Muskegon because we don't keep that data in Muskegon. And Muskegon doesn't keep that data because they're not paid to keep that data.
All right. Well, thank you, panel, for coming. And